again, of contract formation. In order for there to be a contract, there has to be what? It's on the exam.
Offer, acceptance, consideration, legality, and capacity.
Capacity, right? Well, capacity, when we say, again, capacity in the context of legality, they share some of the same concepts, but the idea again of legality, or can be actually idea of capacity, again having the mindset of the contract, right? Having the ability to consent. Remember, the idea with respect to a person's capacity is that they don't have, or they did not have, the mental frame of mind in order to enter into that contract. And we know that there are 3 classes, right, as you recall from the last chapter, that if a person, that the contract can be either invalid, right, it can be either unenforceable, right, it can be invalid on its face, it can actually, one party who did not have the capacity could actually make that contract void, right? So it can be either void, voidable, or valid. Remember those three classes, right? So a contract can be, it's void on its face in which scenario? Mr. Hassan, going back to the last chapter.
Sorry, can you please restate?
When will a contract, if a person is, again, lacking capacity, when will that contract be void? Mr. Hassan. Mr. Hassan. When will the contract be void?
After the person is a minor?
The person is void as a minor, is it void, voidable, or valid? That was the question. Is it void, voidable, or valid? The person is a minor, you said which one?
The person's a minor, I said it's voidable.
Voidable. What does that mean?
Meaning that they will still have to pay, if it's stuff like food or any money, they'll have to pay for it. But as far as getting out of the contract, they can still get out of the contract.
Okay, again, who can help out Mr. Hassan? Because he is having trouble. Mr. Calla is here. Nope. Ms. Copeland is not here. Ms. Green, you got the camera's number. I was that. Ms. Green. No, that's okay. Ms. Kayla Hall. Ms. Hall?
I don't know.
No? Okay, cool. Ms. Sydney Hall. You know, join us though, Ms. Hall. Join us so you can just get in the fun. So hopefully, maybe you might take a stand. Take a stand, Ms. Hall. Yes, Ms. Sydney Hall.
So, what was the question? I got the question.
So the question is, again, for contracts, right, we know that the parties have to have consent. We know that there are 3 states during the context in this conversation of consent, that when a person is lacking consent, the contract can be either void, voidable, or valid. All right? So Mr. Hassan was talking about contracts with respect to minors. And he was saying, correctly, that those contracts are voidable. But he had trouble with understanding why the contracts are voidable. So you tell me, why is that contract voidable?
Isn't it illegal for a minor?
Pardon me?
Isn't it illegal for a minor?
Okay, we're confusing subjects, right? One issue is legality, the other is consent. We're on the issue of consent because it relates to our current contract course, our current chapter, which goes to issues of mistaken fraud and voluntary consent. So again, let me go back to Ms. Kayla Hall. Ms. Kayla, can you chime in at this point?
It's 8:15.
Thank you.
It'll be valid.
The contract would be, with minors, it's what?
There's some people who are incompetent due to age or illness has lucid intervals, temporary periods of sufficient intelligence, judgment, and wisdom. So if they're a minor, they have,
It's valid, you said? All contracts with minors are valid?
it says when the contract may be renewed.
Huh?
Is it renewed?
Okay, let's go to Miss Miss King. Help him out.
Are you asking why it's voidable for a minor?
I'm asking you, again, exactly. 'Cause he started off and said it's voidable, and that was correct. The answer was voidable. And I'm asking you, why is it voidable?
Is it because the minor would have lacked the mental capacity to comprehend its nature, purpose, and consequences?
So he lacked it, and so what makes it voidable as opposed to void?
Because he wasn't mentally incompetent.
He wasn't mentally incompetent, so it's not void, is what you're saying. And so how does the minor get out
How do I get out of it?
of the obligation?
By disaffirming.
By disaffirming, how does he disaffirm?
He does so by coming forward at a reasonable time to speak up.
Okay, so again, the issue here is about whether or not one party to the contract can enforce it. So one party to the contract has the ability to get out or say that he's going to continue, right? That's by ratifying that contract, right? So that's a person, again, who lacked consent, but the law considers that consent not so defective to actually render that contract void. You see what I mean? So that's, again, with respect to minors. Now let's give it another party. So Mr. Hassan, I think you got that one. You can have a seat. So now, the other three people, tell me about the parties who, again, the contracts are either valid or void. Okay? So let's go back to Miss Sydney Hall. Miss Sydney Hall, how about people who, again, are intoxicated? Tell me about that. Class. Is the contract valid or void?
It's voidable.
Voidable, and why?
An intoxicated person, they also voidable.
How about you, Miss King?
It would be voidable if they didn't have, if they weren't at the mental capacity either. They weren't mentally incompetent.
So they were not mentally incompetent. So that contract you said would be voidable until when?
Until they become to a competent stage. Like,
So it's voidable. It's voidable at the time they entered it, if so long as what? They were intoxicated, right? And if they were intoxicated until when? It's voidable. It's voidable. When do they give up the right to make that contract voidable?
when they got intoxicated no more.
When they're no longer intoxicated. So a certain period of time, they have the ability to basically avoid responsibility and say, I was drunk, and so I was not, again, able to comprehend that, right? So that contract, thank you, that contract is voidable, right? So again, now give me a contract that is, and you can have a seat, Ms. King. Now, between the both of you, now give me a contract that's either valid or void in the context of consent. Say 20, you said? Okay, so let's both you guys have a seat. Let me give it to you this time, and then encourage you all to go back and understand that chapter. Again, issues of a contract being void. So as we talked about, when we talk about a person who is declared mentally incompetent by a court, by the time, if the person is mentally incompetent by a court, at the time he entered into that contract, or she entered into that contract is void ab initio, void in its face. There's no way that that person can be held responsible for that contract, all right? However, again, a contract, going back to this person who is mentally incapacitated, if the person is not declared mentally incapacitated, and that person, again, goes through periods of lucidity. Who was saying that? Was that you, Ms. Hall?
Yes.
If that person goes through periods of lucidity, and at the time that they entered into that contract, they were lucid, then that contract is actually valid, right? So again, the issue here having to do with consent goes, again, the person's state of mind at the time that they entered into that contract, right? So now we're going to get into the idea of how the contracts can be unenforceable if the parties have not, again, assented to the contract. That means that they don't have the state of mind. Now, one is the issue of mistake. Tell me now, let's go back to you, give you another chance, Miss Kayla Hall. Tell me now about a mistake. How does a mistake affect a contract?
Are we going back?
Now, we're back now to chapter 15.
All right. So only a mistake of fact.
What are the reasons why a mistake of fact, and what are the elements to that are required in order to get out of that contract in terms of mistake of fact? Why is it? And there are a couple, or actually a couple issues of mistakes. One is a mistake of fact, the other is a mistake of value. Tell me about mistake of fact.
Okay, yeah, unilateral mistake of fact. A unilateral mistake of fact is made by only one of the parties. In general, a unilateral mistake does not give the mistaken party any right to relief from the contract. Bilateral mutual mistakes of fact.
So let me ask. So tell me about the unilateral mistake of fact. When can it be canceled? What must happen in order for it to be canceled?
When can it be enforceable?
Exactly. What must be wrong with that contract?
The other party knew or should have known that the mistake was made, or the mistake was due to substantial mathematical error made inadvertently and without gross negligence.
Exactly. Is there an example you want to give me?
Alina intends to sell her jet ski for $2,500. When she learns that Chen is interested in buying a used jet ski, she sends him an email offering to sell the jet ski to him. When typing the email, however, she mistakenly keys in the price of $1,500. Chen immediately sends Alina an email reply accepting her offer. Even though Alina intended to sell her personal jet ski for $2,500, she has made a unilateral mistake and is bound by the contract to sell it to Chen for $1,500.
So, it was a unilateral mistake, and in this case, again, the other party, did Chen know it was a mistake?
No.
And was the mistake a gross mathematical error or a slight mathematical error?
I think that's a slight matter.
Exactly, because again, it's still in the thousands, right?
Yeah.
But it was just it was off by 1,000, right? So let's give another example. If she's selling a car, right, and the car is worth $20,000, and instead of putting $20,000, she put what? 2,000, right? One drop of the zero. But in that case, one drop of the zero, is that a slight mistake or is that a gross mistake? That's a gross mistake.
It's 8:20.
Thank you. That's a gross mistake. So again, that's the difference, right? That in that context, that is a mistake that can be canceled because of her unilateral error. Okay? All right, you can go ahead and have a seat now. That was Ms. King, got her point. That's also Ms. Hall. Got her point. All right. So now, tell me about a bilateral mistake, Ms. Hall, Sydney.
A bilateral mistake is a mutual misunderstanding concerning a basic assumption on which the contract was made. When both parties are mistaken about the same material fact, the contract can be rescinded by either party.
Either party can be rescinded. Give me an example.
So it's like you and I had a contract and.
What was the example?
You know, like-
I mean, you know, again, I'm just saying for the sake of time. Do you know an example in the book? Okay, well, give me your own.
Okay, so like if me and someone had a contract and I guess we both messed up or we both are.
Give me an example. Use this example that Ms. Hall gave us. Your namesake.
So I guess if he,
So again, she keyed in, she said her jet skis were $1,500, right? When they were actually, again, $2,500, right? So that was her mistake. How about in the other instance, in his mistake, what would it be a mistake that he would have made?
so maybe if he,
So let's just say, for example, that he misread.
yeah, and immediately.
He misread. He said that, okay, so she put 1,500 when she wanted to put 2,500, right? And he said, in this instance, that I was going to say the number was, if his number was off, then that would actually be kind of a counteroffer. But about like a mutual mistake, as was example 15.1. Give me that example 15.1.
Some buys a violin from dead for $250. Although the violin is very old, neither party believes that it is not valuable. Later, however, an antique dealer informs the parties that the violin is rare and worth thousands of dollars. Here, both parties were mistaken, but the mistake is a mistake of value rather than a mistake of fact that warrants contract possession. Therefore, that cannot rescind the contract.
So again, this is a mistake of value versus a mistake of fact. That's 15.1. So if instead of, again, being a mistake over the value, if, for example, there was a mistake about, again, whether the both parties, let's say, for example, thought it was a Stradivarius violin. Does anybody know what a Stradivarius violin is? It's a violin supposedly played by a famous composer, right? So it was a Stradivarius violin. There are only a few of these type of violins that exist. So there was a mistake, not necessarily, and this goes to value, but it's an issue of whether or not it's, again, a type of violin, right? And so both parties thought it was the same type of violin, right? But in this instance, they were mistaken. Then both parties had the ability to get out the contract because they didn't have a meeting of the minds. They thought they were entering into a contract regarding the Stradivarius violin, right? But in this case, it wasn't. And again, that although that goes to value, it's not value alone. It goes to the issue of a fact, right? Whether or not this was that type of violin that they were entering into a contract concern, right?
That's 8:30.
Thank you. All right. So that's again the issue of a mistake that's a bilateral mistake, right? And again, please keep in mind this exhibit 15.1 that again the bilateral mistake is when both parties are mistaken, and then that can be rescinded by either party or a unilateral mistake, and that is again only when one party can again, one person made the mistake, and then the contract is enforceable unless, again, those two elements. One, the party should have known, or that it was a substantial error. Now let's go to the issue of value. I think we talked about it again, that issues of value, meaning mistake of values, are generally going to be enforceable by either party unless, again, the mistake of value was because of mistake of a material fact. Now, that goes back to the point of what we said earlier, right? If it was, again, a mistake of value, again, going back to whether or not this was in a Stradivarius violin, right? Stradivarius violins are worth more, so that goes to value, but it's based upon a fact, right? Both parties entered into the contract, not, again, having a mistake, thinking that it was solely, again, of value, but whether or not they were entering into this contract for a Stradivarius violin. One party thought it was a Stradivarius violin, so therefore they were going to sell it for a higher price, and the other person thought it was a Stradivarius violin, so therefore they were going to buy it at a higher price. However, if they found out later that it was not in the Stradivarius violin, then again, this is a mistake of value, but again, it bleeds over to the point of being a mistake of fact. In that instance, they can be, again, both parties have the ability to rescind that contract, all right? You understand that? Now let's go to the point of fraudulent misrepresentation. The guys who are taking exam, please bring those up here, all right? So again, the issue of fraudulent misrepresentation. Tell me, and so it was Miss, that was Miss Sydney Hall and Kendall Hall, all right. Now, going to Miss Murray. Miss Murray, tell me about fraudulent misrepresentation. Parks, Karim. Great, thank you. Are you doing time? Oh, you're doing time. I'm sorry. That's right. Gotcha. All right. That's Miss Murray doing time. No, you're not Miss Murray. Miss Murray's not even here. Okay. I'm talking to somebody who's not even here. All right. Mr. Muslim, you probably just getting back to us. I will give you some time to get up to speed. You look over St. Eunice Parks. And so, Mr. Thomas, tell me about the issue of fraudulent misrepresentation. We cannot cancel a contract consent.
A misrepresentation of material fact must occur.
You still have to look right on the phone. Yep.
There must be an intent to deceive.
So again, issue of a person having, again, the other person, again, being defrauded. When will there are four things that must happen. And again, it's voidable. Is it voidable, valid, or void? The void, voidable, or valid?
All right, so the first one is a misrepresentation of material fact must occur.
I'm asking you, is the contract valid, voidable, or void? When there's a fraudulent misrepresentation.
It's 8:30.
Thank you.
Is void? Void.
Void? Is it void on the face if there's a fraud?
Oh, it's voidable.
Voidable. Again, you got to understand the distinction. Void means it's on its face there is no contract, right? There is no contract. Like the person who is again mentally incompetent has been declared mentally incompetent. When the person who is being declared mentally incompetent enters into the contract, there is no contract, right?
It's something that's illegal.
Pardon me?
Like,
Or if it's illegal, exactly. Another, going back to legality, right? Because again, legality is one of the 5 elements. If the contract is illegal, if it's a contract to sell drugs, that contract is absolutely void. There's no way in which it can be enforced, right? The issue of whether or not it's the contract has been, a person's consent has been induced by fraud, however, that contract, again, it could be for, again, something legal, let's say purchasing apples, right, for example, that's legal. But the question is, for you, Mr. Thomas, is, again, you said it's what?
Avoidable.
Voidable. And so by it being voidable, who has the power to rescind that contract?
Either one of the other parties.
Huh? There's two parties to a contract.
Either party.
You're saying that either party?
Mr. Tucker, help him out.
The offeree, he can go not take that contract.
Again, you have two parties. One, again, is the person who is offering the contract, right? Offerer, and the other is offeree. In this context, who is being defrauded?
The offerer.
Right. So again, the issue, the question that I now ask, going back to you, Mr. Thomas, is who's the person who can rescind the contract?
The offeree.
The person who is being defrauded, right? The person who got duped. It's a fraud. Now, give me an example.
It says, actor Tom Selleck contracted to purchase a horse named Zorro from his daughter, from Dolores Secuca. Secuca acted as though Zorro was fit to ride in competitions, when in reality, the horse suffered from a medical condition. Selleck filed a lawsuit against Secuca. Filed a lawsuit against Secuca for wrongfully concealing the horse's condition and won.
Exactly. So again, that is an example in which somebody, again, who was defrauded. The innocent party who was defrauded had the right to rescind that contract. And again, in this instance, that's what happened here. The contract was declared as being unenforceable. Now let's go back again to you, Mr. Tucker. Tell me again, what are the following elements of misrepresentation?
Misrepresentation. First element of providing fraud is to show that misrepresentation of the material fact has occurred. The misrepresentation can occur by words or actions. For instance, the statement, this sculpture was created by Michelangelo, is a misrepresentation of fact. If another artist sculptured this statue.
Okay. Next, what's the second element?
Misrepresentation by conduct, statements of opinion, misrepresentation of law, and misrepresentation by silence.
Okay. So again, we said that the issue of, there's again several areas of misrepresentation. We said one is the material fact. There also must be an intent to what?
Deceit.
There has to be an intent to deceive, right? What's the third one, Mr. Tucker?
The innocent party must justifiably rely on the misrepresentation.
Right. So other person must say, okay, thinking, again, going back to the Selleck instance and the example given, Mr. Selleck actually thought that the horse named Zorro was fit to ride in competition. So he relied upon that, and so therefore he paid a higher value, right? And lastly, what must be shown?
To collect damages, the party must have been harmed as a result of result of the misrepresentation.
Exactly. So if Mr. Selig never paid the money, then there would have, even though he contracted, he wouldn't be able to show damages. So you actually have to pay that increased price, right? So you don't only pay again for what a horse that again was not fit for competitions. Again, even though he agreed to pay higher and the other party accepted the lower amount, he could not then sue the other party again for his again being duped or being defrauded because he didn't pay the higher amount. And because he didn't pay the higher amount, there would be no what? Starts with a D. No, what's the point? The last time they has to be shown what?
Oh, damages.
Damages. There are no damages, okay? So again, those are the four elements of, again, issue of fraudulent misrepresentation. Now, you can have a seat. But there are, again, in terms of, again, the issue of misrepresentation, there are several instances in which misrepresentation can occur. And I want to ask now Mr. Willis to tell me what are those instances in which misrepresentation may occur. What are they? Mr. Willis? Mr. Willis, we conversing here in class?
I don't know right now.
Okay, hold on. Are we conversing?
Oh.
So if you don't know, then let's ask somebody to help you, right? Let's ask Mr. Parks. Mr. Parks? What are the ways in which misrepresentation can be shown? Bob.
In general? I was trying to copy my notes.
You said trying to copy notes. You don't know. That's what you're saying, right?
I'm trying to get more clarity with the question.
I'm asking you, again, what are the ways in which misrepresentation can be shown by?
Is it misrepresentation by conduct?
That's one. And so tell me about that one.
When a party takes specific action to conceal a fact that is material to the contract.
Exactly. All right. And so if a seller, for example, prevents a buyer from learning of some facts, right, that's material to the contract, such behavior is what?
Misrepresentation
by conduct. Okay, great. Now give me the second one. So that's one by you, Mr. Willis. Now going to Mr. Parks. Give me another one.
Statements of opinion.
Statements of opinion. Tell me about that one.
It says statements of opinion and representations of future facts generally are not subject to claims of fraud.
So give me an example.
This land will be worth twice as much next year, or this car will last for years and years.
Exactly. That's a what?
Statement of opinion.
That's an opinion.
Not a fact.
That's not a fact. Say, okay, I'm about to make, if you buy this book, you're gonna become a millionaire. You know what I mean? You're gonna become a millionaire if you buy this book. Now, that it is, again, he didn't even say you might become a millionaire, right? He said, if you buy this book, this book's going to help you become a millionaire, right? It is assumed, again, he didn't say, he said, I guarantee you that you'll become a millionaire, right? There might even also still be, again, some way out of it, right? But it is assumed that this is, again, a statement of an opinion, not of a fact, right?
It's 8:40.
Thank you. So again, what's the next one then, Mr. Willis?
Misrepresentation of law.
All right, so tell me about that.
Misrepresentation of law ordinarily does not entitle a party to relief from a contract exception to this rule occur when the misrepresenting party is in a profession that is known to require greater knowledge of the law than the average citizen possesses.
Give me an example.
If Kamara had been a lawyer for a real estate broker, her willful misrepresentation of the area zoning laws probably would have been.
No, I asked, that's not the full example. You can
Oh,
go
yeah. Go back. Exit. Kamara has a parcel of property that she is trying to sell to Pike. Kamara knows the local ordinance prohibits the construction of anything higher than 3 stories on the property. Nonetheless, she tells Pike, you can build a condominium 100 stories high on this land if you want to. Pike buys the land and later discovers that Kamara's statement is false. Normally, Pike cannot avoid the contract because people are assumed to know state and laws.
But if she was a lawyer, then he could have relied upon it, right? So in the instance, this is almost similar to an opinion, right?
Yeah.
It's an opinion about the law. However, if that person's opinion was coming from a lawyer, then he could rely upon that, all right? So that's the again, that's the distinction here, right? So now going back to you, Mr. Parks, tell me about the other one.
Misrepresentation by silence.
And when does that occur?
Ordinarily, neither party to a contract has a duty to come forward and disclose facts. Therefore, courts typically do not set aside contracts because the party does not volunteer pertinent information. An example?
Yep.
When is selling a car that has been in an accident and has been repaired, he does not need to volunteer this information to a potential buyer. If, however, the purchaser asks Jim if the car has had extensive body work and he lies, he has committed fraudulent misrepresentation.
Exactly. So again, going back to, you guys can have a seat.
That's Mr. Parks. Mr. Wills.
So tell me, going back to the issue of intent to deceive. Tell me, again, an example. First of all, tell me what are the, again, another word for the intent to deceive, Mr. Hassan. Another word for intent to deceive. How about you, Mr. Muslim? Help him out.
Scienter.
Scienter. Tell me what scienter.
It means guilty knowledge.
And it signifies what?
It signifies the intent to deceive.
That the party has an intent to deceive. And it exists when?
It exists when an element of fraud is knowledge of the part of misrepresenting party that facts have been falsely represented.
So it exists if a party what?
If a party has facts that have been falsely represented.
It exists if a party what?
Knows a fact is not as stated.
Exactly. And also, if what?
And also, if a party makes a statement that he or she believes is not true, or makes a statement reckless.
It's 8:50.
Thank you. All right. So what we'll do here is
295.
we will finish up this this chapter instead of concluding. We'll finish it up, and then we'll talk about the group projects in the next class. All right.